Artificial intelligence and legal risk, the accountability era, agentic AI liability. Who is liable when autonomous AI agents breach contracts or commit fraud? Introduction. Artificial intelligence is the ability of machines to simulate human intelligence, such as learning, reasoning, and decision making. AI is rapidly transforming modern legal and commercial landscapes. Autonomous AI agents are software systems capable of making decisions, learning, and acting with minimal human intervention, and are now executing trades, drafting contracts, negotiating terms, and engaging with consumers in ways once exclusive to humans. These developments present profound questions about legal liability when such agents act in ways that harm third parties, breach contractual obligations, or commit fraud. The central issue is who should be liable when an autonomous agent causes contractual breaches or fraudulent conduct. Traditional legal frameworks assume human or corporate agency, but autonomous AI sits uneasily within these assumptions. If an AI commits fraud, who is the tortfeasor? The AI itself, its developer, its deplorer, or the owner? If it breaches a contract, can AI be banned by contract law? If so, who bears responsibility? In this video, I'll talk you through current legal doctrines, conceptual and normative gaps, comparative approaches, proposed frameworks for accountability, and assess policy implications. It is argued that existing liability regimes must evolve to balance innovation with accountability, fairness, and effective deterrence. Let's start by looking at key concepts. Autonomous AI agents. Autonomous AI agents are systems capable of perceiving their environment, making decisions, and acting to achieve specified goals without direct human control. Examples include deep reinforcement learning training to bots, automated contract negotiators, robo-advisors, and natural language agents interacting with consumers. Breach of contract versus fraud. Breach of contract occurs when a party fails to fulfill duties under a contract without lawful excuse. Fraud, on the other hand, involves intentional deception for unlawful gain. In criminal law, fraud requires mens rea or intent to deceive, which complicates attribution for non-human agents. Understanding these distinctions is critical because contract liability often focuses on strict liability for performance obligations, whereas fraud involves intent, a traditionally human attribute. Now, traditional liability frameworks and their doctrinal extension. Autonomous AI systems make the law more complicated because they do things on their own. When an AI system breaks a contract or commits fraud, the law must decide who is responsible. To figure that out, lawyers look at existing rules about contract, agency, negligence, employer responsibility, strict liability, business risk, and product defects, and consider how those rules might apply or need to change for AI. Now, contract law and agency attribution. Legal personality and contractual capacity. Under traditional common law rules, only legally recognized persons, human beings or companies can enter into contracts. A person or company can also be bound by what their authorized agent does. AI systems are not legal persons. They cannot enter contract on their own or hold legal rights and duties. So if an AI system is involved in making a contract, the law must treat a real person or company as responsible, usually the owner or the user or the business behind it. Classical agency principles. Agency law helps connect AI actions to human responsibility. A person or company, the principal, can be legally responsible when the agent acts with actual authority that is clearly given or implied, or the agent appears to have authority and others reasonably rely on that appearance. Agency law does not require the agent to be human. What matters is that the principal allow the agent to act on their behalf. Because of this, courts may treat AI systems like automated trading programs, internal company compliance software, decision support tools. If the AI actions can be traced back to human approval or control, it makes sense under existing law to hold the person or company behind it responsible. Autonomous learning and the scope of authority. Advanced AI systems make agency law harder to apply because they learn and change over time, produce new and unexpected outputs, sometimes behave in unpredictable ways. If an AI does something that was not directly programmed but results from its training, the question becomes, was that action still within the authority given by the person or company behind it? Courts will likely focus on foreseeability. If the harmful action was reasonably predictable based on how the system was designed and used, the owner or company will likely be responsible. If the action was completely unexpected and outside what could reasonably be anticipated, responsibility may shift to the developers under product liability rules. In the end, the key question is whether the AI is simply a very advanced tool or whether its actions can legally be treated as those of the person or company that authorize its use. Tort law, negligence and fault-based liability. Under the law of negligence, a person is responsible only if four things are proven. 1, they owe the duty of care. 2, they breached that duty. 3, the breach caused the harm. And 4, there was actual damage. When harm is caused by an AI system, the main question becomes whose behavior amounts to the breach. Possible responsible parties include the developers, if the system was badly designed, the deployers, if they fail to supervise or monitor it properly, the users, if they misuse it, and the company that benefit from using the AI. Negligence becomes more complicated with AI because it can be difficult to prove exactly how the harm happened, especially when the system learns over time and its behavior is not fully predictable. Vicarious liability. Vicarious liability means one person can be held legally responsible for the wrongdoing of another, even if they did nothing wrong themselves. Traditionally, employers are responsible for wrongful acts committed by their employees during the course of their work. This rule is based on 3 main ideas. 1, the employer has control over the employee. 2, The employer benefits from the employee's work. 3. The employer is better placed to spread or absorb the risk. Modern law uses a close connection test. This asks whether the wrongful act is closely linked to the employee's authorized duties. If the connection is strong enough, the employer can be held liable. Now, application to AI. AI systems are similar to employees in some practical ways. They work within rules set by the people or companies using them. They help generate profit or economic value. They create risk as part of business activities. If courts treat AI like employees, then the company using the AI may be responsible for harm it causes, even if the company was not personally at fault. But AI is not the same as a human employee. It has no consciousness. It cannot form intentions. It cannot be punished or discouraged in the way a person can. Because of this, holding companies responsible for AI under vicarious liability will not be based on moral blame. Instead, it would be justified by ideas about managing risk fairly and ensuring businesses bear the cost of the risks they create. Strict liability and enterprise risk. 1. Enterprise risk theory. Enterprise risk theory says that a business that creates risk in order to make profit should also bear the cost when that risk causes harm. This idea supports workers' compensation systems, product liability laws, strict liability for dangerous activities. When applied to AI, the reasoning is simple. If a company uses an autonomous system and that system breaks a contract or commits fraud, the company created the risk and benefited from it. Therefore, the company should be legally responsible for the harm that results. 2. Economic justification. Enterprise liability serves several important purposes. It encourages companies to design and test AI systems safely. It motivates them to maintain strong internal compliance and oversight. It ensures that victims can claim compensation from parties that have the resources to pay. It helps prevent gaps where no one is clearly responsible. Without enterprise liability, victims could struggle to get compensation if developers cannot pay. Responsibility is spread across multiple parties, or legal jurisdictions make enforcement difficult. 3. Distributed responsibility. Modern AI systems involve many different participants, including the developers who build the models, 2. The providers of the data used to train them, 3. The integrators who combine the system into applications, 4. The companies that deploy the AI, 5. The end users who operate or rely on it. And this creates a problem of shared or distributed responsibility. To address it, the law may use tools such as joint several liability, holding multiple parties fully responsible, proportionate fault, assigning responsibility based on each party's role, regulatory mechanisms which clarify who must take responsibility under specific rules. E. Product liability and defect analysis. Product liabilities offers another way to hold AI systems accountable, but it needs some adaptation for modern technologies. One, is AI a product? Traditional product liability applies to physical products, but courts increasingly recognize that software, digital systems, and smart technologies can also count as products. A distinction may arise between off-the-shelf AI systems, which are more like traditional products, and customized AI as a service platforms, which are so closer to services. The way liability is applied can differ depending on this classification. Categories of defects. Product defects generally fall into three types, which translate to AI as follows: manufacturing error, errors in deployment, such as corrupted training data or faulty configuration; design defects, system-wide problems like missing safeguards, unsafe levels of autonomy, or biased algorithms; failure to warn, not disclosing known risk, unpredictability, or the potential for misrepresentation. Now, strict product liability. Unlike strict liability, a plaintiff does not need to prove negligence. They only need to show a defect and that caused it. This approach is lawful in AI cases because technical complexity and information asymmetry can make negligence hard to prove. However, strict liability also has downsides. It can raise compliance costs, slow innovation, and increase insurance premiums. Striking the right balance between holding AI accountable and supporting technological progress is therefore essential. Fraud and intent in AI systems. Fraud normally requires four things: a false statement or misrepresentation, knowledge that the statement is false, intent to make someone rely on it, and actual reliance that causes harm. AI systems do not have minds. They cannot truly know something is false or intend to deceive. Because of this, any fraudulent intent in AI's actions must be legally attributed to a human or company responsible for designing, deploying, or controlling the system. Attribution models for fraud. There are three ways the law can assign responsibility when AI causes deception or fraud. 1. Programmer intent model. If the developers deliberately design the AI to mislead or manipulate, the law can attribute that intent to them. 2. Corporate knowledge model. A company can be held liable if senior management approves the AI deceptive use, or failures in compliance allow foreseeable deception to occur. 3. Recklessness standard. Courts may treat reckless behavior as enough for liability. For example, deploying an AI system that has a known high risk of misleading others can meet the legal threshold for culpability. In addition, consumer protection laws may hold companies responsible for unfair or deceptive practices even without proving intent in the traditional sense. 4. Comparative and regulatory approaches. AI liability is evolving differently across the world, reflecting each jurisdiction's legal traditions and policy priorities. A. The European Union. The EU uses a risk-based regulatory system that focuses on classifying AI systems according to their level of risk. High-risk systems must undergo mandatory risk assessment, include human oversight, and meet transparency requirements. Changes to product liability rules are intended to cover digital products, reduce the burden of proof for claimants, and strengthen strict liability mechanisms. Overall, the EU approach leans toward strict liability supported by regulation, with a strong emphasis on protecting consumers. United States. In the United States, AI liability relies mainly on existing tort law, including negligence and product liability, as well as agency principles, consumer protection enforcement, and regulatory oversight by agencies like the Federal Trade Commission. The American approach favors gradual judicial adaptation rather than broad statutory reform, allowing courts to incrementally shape how AI responsibility is applied. The United Kingdom. UK focuses on maintaining existing legal frameworks while clarifying how liability can be attributed and when harm is foreseeable. It also encourages insurance-based solutions to manage AI risks. This reflects a cautious, market-oriented philosophy relying on incremental adaptation rather than sweeping regulatory changes. D. Nigeria and other common law jurisdictions. In countries such as Nigeria, Ghana, South Africa, Canada, there is currently no AI-specific liability regime. Courts would apply ordinary principles of contract, agency, negligence, and consumer protection. The lack of statutory guidance can create uncertainty and inconsistent legal outcomes when addressing AI-related harm. Note, while the EU prioritizes regulating strict liability, the US and UK focus on adapting existing legal doctrines, and emerging jurisdictions like Nigeria rely on traditional common law, leaving significant room for development. A review of legal approaches to AI liability reveals 4 main models. 1. Agency-based attribution. AI is treated like an agent, and responsibility for its actions is assigned to the company or human, the principle that controls or authorizes it. 2. Enterprise risk model. The business that profits from the AI system also bears the risks it creates, making the company responsible for any existing resulting harm. 3. Product liability model. Developers can be held liable if the AI system has design defects, manufacturing errors, or fails to warn users of known risk. 4. Regulatory hybrid model. This combines statutory oversight with strict liability rules, often allowing compliance-based defenses to limit or manage accountability. Each model assigns risk in a different way. In practice, a consistent framework may need to combine elements from these approaches, depending on the sector, whether it involves financial AI, healthcare applications, consumer services, or autonomous trading systems. Transitionally, autonomous AI systems highlight challenges in legal doctrines that were originally designed for humans. Traditional rules such as agency, negligence, vicarious liability, enterprise risk, product liability, and fraud still apply, but they need to be carefully adjusted for AI. The main difficulty is not that the law lacks tools, but that these tools must be combined in a clear and consistent way. The goal is to create a liability framework that is predictable, supports innovation, and can handle shared responsibility and the complexity of AI technology. 5. Integrated frameworks and real-world application for agentic AI liability. The debate over who should be responsible for autonomous AI systems becomes most significant when legal theories are applied to real incidents. By examining how agency law, enterprise risk theory, product liability, and regulatory oversight intersect, we can see both the flexibility and limits of existing legal structures. A thorough analysis of proposed liability frameworks alongside real-world case studies helps illustrate how legal doctrines operate in practice when AI causes harm. Foundational attribution models for autonomous AI agents. 1. Extended agency attribution. A conservative legal approach treats AI systems as agents or tools of a human or corporate principle. Under this model, if the AI acts within its program authority, the principal deploying it is responsible. Even if the AI behaves unpredictably, but within foreseeable operational boundaries, the principal may still bear liability under risk allocation principle. If harm stems from design flaws or hidden limitations, responsibility may still shift toward the developers or be shared between parties. To apply this model effectively, courts must clarify the scope of authority delegated to the AI, whether the AI's actions fall under actual or apparent authority, the degree to which harm was reasonably foreseeable, and standards for supervision and oversight. This approach maintains continuity with traditional agency law. Giving an AI autonomy in execution does not remove accountability from the human or corporate principle. Execution autonomy does not equal liability autonomy. Enterprise risk internalization. Enterprise risk theory holds that those who profit from activities that create risk should also bear the cost when harm occurs. Applied to AI, companies deploying autonomous systems are best positioned to evaluate, manage, and insure against potential risks. Enterprises benefit economically from automation, so they should also bear the losses that may result. Liability under this theory encourages safer AI design and stronger compliance systems. This approach is particularly persuasive where harm arises not from individual negligence but from systemic deployment of technology across an organization. 3. Nuanced product liability. Product liability provides another way to assign responsibility, especially when AI systems are commercial products rather than internal tools. Key considerations include whether the AI was defectively designed, whether safeguards were adequate, whether warnings about limitations were sufficient, and whether data inputs created foreseeable risk of malfunction. AI complicates traditional product liability because machine learning systems evolve after deployment. Causation may involve multiple components across data pipelines, and harm can result from interactions between multiple systems. Liability may therefore require a hybrid approach, sharing responsibility among developers, system integrators, and deployers. 4. Enhanced strict liability for high-risk AI. For AI systems with particularly high impact, such as algorithmic trading platforms, financial bots, or autonomous vehicles, traditional fraud-based legal rules may not be enough. A strict liability approach could address these risks by assigning responsibility regardless of negligence, encouraging thorough pre-deployment testing, promoting conservative risk modeling, and reducing the evidentiary burden for victims seeking compensation. This approach is similar to the way the law treats inherently dangerous activities. Mandatory insurance and compensation funds. Because AI harms can be technically complex and involve multiple actors, mandatory insurance systems offer practical solutions. Possible mechanisms include compulsory liability insurance for AI deployers, sector-specific compensation funds, and no-fault compensation systems similar to motor vehicle insurance. These frameworks prioritize ensuring victims are compensated while still allowing innovation to continue. Regulatory oversight and client-based defenses. Regulatory governance increasingly complements traditional tort law. Pre-deployment requirements may include risk assessment, transparency and auditability standards, human oversight mandates, and certification procedures. Demonstrating compliance with these regulations can serve as a partial defense, evidence of due care, or a factor in reducing damages. Regulation is particularly important in complex systemic AI contexts where relying on private lawsuits alone cannot maintain market stability or protect the public. Case studies, real-world AI harm and doctrinal application. A. Algorithmic trading and the 2010 flash crash. The event. On May 6, 2010, the US financial market suffered a sudden and dramatic drop, with the Dow Jones Industrial Average falling nearly 1,000 points before quickly rebounding. High-frequency trading algorithms and other automated systems interacted in ways that amplified market volatility. No single algorithm caused the collapse. Instead, cascading automated reactions across multiple systems created systemic instability. Doctrinal implications. Agency attribution. Each algorithm acted as a tool of the firm, that deployed it. Under agency principles, any unlawful or harmful trading would be attributable to the deploying firm. Enterprise risk. Firms profited from automation and speed, creating systemic vulnerabilities. Enterprise theory supports internalizing such costs through regulatory capital requirements and compliance obligations. Now, product liability. If a particular trading algorithm lacks proper safeguards, plaintiffs might allege a design defect. However, distributed causation makes proof challenging. Analytical insight. The flash crash illustrates the concept of collective algorithm effect. Harm arose from interactions between systems rather than from isolated misconduct, showing that traditional fault-based doctrines struggle when responsibility is spread across a complex ecosystem. B. Knight Capital Group trading failure 2012. The event. In August 2012, Knight Capital deployed trading software containing a coding error, and within 45 minutes, the malfunction executed millions of unintended trades, resulting in $440,000 million in losses. Liability analysis. Negligence. The firm failed to adequately test and supervise the deployment. Traditional negligence principles clearly apply. Enterprise risk. The firm itself bore the losses, reflecting the principle that entities benefiting from risk should internalize the consequences. Product liability hypothetical extension. If a third-party vendor had supplied the defective code, developers might have been liable for design or manufacturing defects. Doctrinal significance. Unlike the flash crash, this incident involved a clear causal chain, demonstrating that many AI-related harms extended established software negligence principles rather than creating entirely new legal challenges. C. AI contract bots and automated breach. Autonomous contract systems are increasingly used to negotiate pricing, execute smart contracts, adjust supply chain commitments, trigger termination clauses based on predictive analytics. Disputes have arisen when systems cancel orders due to misclassified data, failure to meet purchase obligations, and trigger terminations based on flawed inputs. Liability implications. Agency attribution. AI acting within delegated authority binds the principle. Errors do not automatically excuse contractual performance. The mistake doctrine. Courts may evaluate whether algorithmic errors constitute unilateral or mutual mistakes, but the deployer usually bears the risk of automation decisions. Product liability. If a breach arises from defective third-party contract software, indemnification claims may apply. Core principle. Delegating tasks to AI does not remove human contractual responsibility. Legal obligations remain centered on the human principle even when execution is automatic. Algorithmic price fixing and collusion. Machine learning pricing systems can independently converge on supra-competitive prices without explicit human coordination. The legal challenge. Antitrust law traditionally requires proof of an agreement and intentional coordination. When AI stabilizes collusive outcome on its own, courts may consider whether deploying AI with foreseeable collusive potential count as recklessness, and whether constructive knowledge can substitute for direct intent. This scenario represents a shift from focusing on subjective intent toward a risk-based accountability model. E. AI-generated misrepresentation and consumer harm. Automated chatbots and underwriting systems have caused consumer harm by providing incorrect benefit eligibility information, misclassifying insurance applicants, misrepresenting contractual terms. In such cases, liability is assessed through a combination of agency, product liability, and consumer protection principles, emphasizing that human deployers remain accountable for harms caused by AM outputs. The question of fraud. Fraud normally requires intent, which AI cannot possess. However, courts may hold companies liable if there is corporate recklessness or a failure to supervise the AM system properly. Negligence and consumer protection. Consumer protection laws often impose liability without needing proof of intent. Regulatory enforcement. Regulatory agencies stress transparency, auditability, and oversight, making clear that automation does not protect companies from responsibility for deceptive practices. F. Autonomous vehicles as a template. Accidents involving autonomous vehicles show how hybrid liability can work. Here, developers may face product liability claims. Deployers can be sued for negligence. Owners might bear statutory liability. This ecosystem approach provides a model for broader agentic AI systems, emphasizing shared responsibility, insurance-backed compensation, regulatory certification, and layered accountability. Recurring themes across doctrine and practice. 1. Interaction-driven harm. AI-related harm often results from system interactions, data dependencies, feedback loops, and widespread adoption. Traditional laws assume individual wrongdoing, but AI creates distributed causation. 2. Enterprise actors as liability anchors. In all case studies, corporations deploy and profit from AI. Enterprises are solvent and identifiable, and public policy support holding risk, creating actors accountable. Diminished centrality of intent. In cases involving fraud or collusion, courts increasingly focus on foreseeability, constructive knowledge, recklessness, and risk creation. The emphasis shifts from subjective intent to objective risk management. Regulatory law as structural supplement. Where systemic risk is high, as in financial markets or autonomous vehicles, regulatory oversight often comes before litigation. Regulation sets safety standards, encourages compliance before harm occurs, provides audit trails, and shapes liability rules. Tort law and regulation work together to manage AI risks. Transitional synthesis. The key insight from these frameworks and case studies is clear. AI liability is not about holding machines responsible. It is about allocating risk among the humans and organizations that design, deploy, profit from, and regulate autonomous systems. Effective liability models must preserve incentives for innovation, ensure victims are compensated, maintain market stability, and integrate agency law, enterprise risk, product liability, and regulatory governance. Agentic AI challenges the law not by removing responsibility, but by distributing it across complex technological ecosystems. Legal systems do not need entirely new principles. They need to adapt and integrate established doctrines to handle distributed, adaptive, and semi-autonomous systems operating at scale. Comparative law analysis. Regulatory and liability approaches in the EU, US, UK, and Nigeria. Liability for autonomous AI systems cannot be resolved just by adjusting existing legal doctrines. Increasingly, jurisdictions are combining traditional tort and contract law with regulatory frameworks specifically designed to address AI risks. A comparison of the European Union, United States, United Kingdom, and Nigeria shows significant differences in regulatory philosophy, institutional structures, and approaches to assigning liability. This section examines in detail how each jurisdiction is governing agentic AI and the consequences for issues such as contractual breaches, fraud, enterprise risk, and product liability. 1. The European Union. The European Union has established the most comprehensive and centralized framework for AI regulation worldwide. The EU AI Act, a risk-based governance model. The EU's Artificial Intelligence Act classifies AI systems according to risk levels. 1. Unacceptable risk systems, such as certain social scoring tools, are prohibited. 2. 2. High-risk systems, including critical infrastructure, credit coding, and employment decision tools, are subject to strict regulation. 3. Limited risk system must meet transparency requirements. Minimal risk system face minimal oversight. Implications for agentic AI liability. High-risk AI system must comply with mandatory conformity assessments, documentation and traceability, obligations, human oversight requirements, and robust risk management framework. Non-compliance can lead to administrative fines, support negligence per se claims in civil litigation, and shift evidentiary burdens in harm cases. While the Act does not itself create comprehensive civil liability rules, it provides a regulatory backbone that strongly influences tort analysis. The AI Liability Directive proposed The proposed AI Liability Directive aims to harmonize fault-based claims involving AI. Its key features include a irrebuttable presumption of causality if providers fail to meet AI Act obligations, disclosure requirements obliging defendants to provide relevant evidence, and lower evidentiary burdens for victims in technically complex cases. This is especially significant for agentic AI breaches and fraud, where causation is difficult to trace. The directive addresses the international asymmetry between victims and AI developers. 3. Product liability reform. The EU has also modernized product liability through revised Product Liability Directive. Here, software and AI systems are explicitly treated as products. Post-market updates and learning systems are recognized. The definition of defect has been expanded, and recoverable damages are broadened for autonomous AI. Developers may face strict liability to defective design. Continuous learning does not shield manufacturers from responsibility, and cybersecurity vulnerabilities may qualify as product defects. 4. Regulatory philosophy. The EU model emphasizes ex ante regulation, strong administrative enforcement, structured risk categorization, and harmonized cross-border standards. Effectively, the EU combines regulation and civil liability into a coordinated system designed to reduce uncertainty and enhance protection for victims. 2. United States. sectoral regulation, and litigation-centered development. Unlike the EU, the US has not enacted a comprehensive federal AI statute. Governance is primarily sectoral, relying on agencies, litigation, and executive guidance. 1. Regulatory fragmentation. Key regulatory actors include Federal Trade Commission (FTC), which enforces rules against deceptive AI practices. Securities and Exchange Commission (SEC) monitors disclosures in algorithmic trading. Commodity Futures Trading Commission (CFTC) oversees derivatives trading of the algorithms, and National Highway Traffic Safety Administration (NHTSA) regulates autonomous vehicles. The sectoral approach focuses on consumer protection, disclosure obligations, anti-deception standards, and market stability. 2. Executive policy framework. The federal government has issued guidance, notably the Executive Order on Safe, Secure, and Trustworthy Artificial Intelligence. It directs agencies to develop AI safety standards, encourages red teaming for advanced models. It highlights civil rights and anti-discrimination safeguards, and sets federal procurement standards. While the executive order does not directly create private legal claims, it shapes regulatory expectations and establishes benchmarks that influence future litigation. Now we turn to tort and product liability dominance. Tort and product liability dominance. In the United States, AI liability is expected to develop largely through established legal doctrines, including negligence, strict product liability, failure to warn claims, fraud and misrepresentation, and securities litigation. Historically, American courts have adapted existing doctrines to emerging technologies, such as pharmaceuticals, aviation, and software. For agentic AI, deployers remain the primary defendants, while developers may face claims for design defects. Class action mechanisms can amplify exposure, and punitive damages are possible in particularly egregious cases. Strengths and weaknesses. The US system offers flexibility, case-by-case adaptation, strong discovery procedures, and the potential for significant damage award. However, it also suffers from regulatory fragmentation, uncertainty for innovation, high litigation costs, and potential inconsistency across states. Overall, the US approach relies more on ex-post litigation than on ex-ante regulatory certification. In the United Kingdom, principles-based innovation-oriented governance following Brexit, the UK has pursued a distinctive path from the EU. Rather than enacting a comprehensive AI statute, the UK has adopted a principle-based framework of emphasizing safety, transparency, fairness, accountability, and contestability. Regulators apply these principles within their respective domains. Regulatory institutions in the UK include the Financial Conduct Authority (FCA), the Competition and Markets Authority (CMA), the Information and Commissioner's Office (ICO), which plays a central role where AI intersects with data protection under UK GDPR. Common law adaptability. The UK's common law system can adapt through negligence, vicarious liability, enterprise liability, contractual risk allocation, and fiduciary obligations. For example, for AI, agentic AI, vicarious liability may apply if AI functions like an employee or tool. Enterprise risk principle can justify liability for systemic harms, and contract law binds principles for AI-initiated jurisdiction transactions. Regulatory philosophy. The UK emphasizing pro-innovation regulation, flexible oversight, and alignment with international standards while avoiding over-regulation. Compared to the EU, the UK relies more heavily on regulatory discretion and the evolution of common law. Nigeria emerging frameworks and institutional development. Nigeria represents a developing jurisdiction in AI governance. Each digital transformation strategy relies on institutions like the National Information Technology Development Agency (NITDA), the Nigeria Data Protection Act 2023, and the National Digital Economic Policy and Strategy. While NITDA has issued AI policy drafts and data governance guidelines, comprehensive AI legislation is still in development. Liability under existing law. Currently, AI-related harm would be addressed through contract law, tort law, including negligence, product liability, limited but evolving, fraud statutes, and consumer protection regulations. Corporate actors deploying AI would likely bear liability under negligence, agency principles, or enterprise responsibility. Nigerian courts often reference English common law, suggesting continuity with UK doctrines. Regulatory challenges and opportunities. Nigeria faces constraints such as limited technical capacity, enforcement resource gaps, judicial backlog, and evolving digital infrastructure. Opportunities include adopting harmonized international standards, using insurance-based solutions, and integrating AI governance into key sectors like fintech. Comparative synthesis. Examining AI regulation across the European Union, United States, United Kingdom, and Nigeria reveals 4 distinct approaches to liability and governance. The European Union. The EU adopts a structured, risk-based, and pro-victim model anchored in harmonized legislation. The AI Act clarifies AI systems by risk, while complementary reforms such as proposed AI Liability Directive and revised Product Liability Directive support victim compensation, reduce evidentiary burdens, and promote legal certainty across borders. Preventive regulation and ex-ante compliance obligations are central. In the United States, the US relies on a sectoral, litigation-driven approach. Regulation is fragmented across agencies and states, and liability is primarily determined through tort law, product liability, and consumer protection doctrines. Case-based adaptation dominates, producing a flexible but sometimes uncertain legal landscape. Courts play a central role, and companies face civil liabilities more than regulatory pre-approval. United Kingdom. The UK occupies a middle ground, combining a principles-based framework with common law adaptability. Liability stems from negligence, vicarious and enterprise liability, and contractual doctrines. The system is flexible and incremental, allowing judicial refinement over time without comprehensive statutory reform. Nigeria represents an emerging adaptive framework. Liability is rooted in common law principles, supplemented by nascent policy guidance and regulatory institutions like NICDA. Governance is developmental, focusing on building capacity, aligning with global standards, and gradually integrating AI oversight into existing legal structures. In all totality, the EU demonstrates a harmonized, risk-oriented, pro-victim approach. The US favors litigation-driven, case-based development. The UK balances principles-based flexibility with incremental common law evolution, and Nigeria shows an adaptive emerging model. Together, these jurisdictions illustrate the diverse ways legal systems are addressing the complex challenges posed by autonomous and intelligent technologies. Allocation of responsibilities. Across all jurisdictions, enterprises remain the central anchors of AI liability as they deploy and profit from autonomous systems. Developers face exposure under product liability or negligence doctrines, while deployers are accountable for contractual and operational obligations. Increasingly, regulatory compliance shapes civil liability standards and influences courts' determination. Treatment of intent and fault varies by jurisdiction. In the EU, liability is shifting toward structured causality presumptions, whereas the US emphasizing negligence and discovery-driven proof. The UK relies on doctrinal adaptation of common law, and Nigeria is likely to follow UK-derived negligence frameworks. Strict liability and insurance are handled differently across systems. The EU demonstrates the strongest movement toward structured liability presumptions. The US relies on litigation and potential punitive damages. The UK may adopt targeted regulatory interventions, and Nigeria could benefit from mandatory insurance schemes for high-risk AI sectors. Comparative insight globally. The global landscape shows no single solution for agentic AI liability. Jurisdictions reflect their deeper legal traditions. 1. EU civil law harmonization with structured risk allocation. 2. US adversarial litigation culture emphasizing case-based remedies. 3. UK common law pragmatism balancing innovation and accountability. 4. Nigeria developmental adaptation leveraging inherited doctrines and emerging institutions. Despite these differences, a shared principle emerges. Autonomous AI systems do not remove human or corporate responsibility. Liability increasingly converge on enterprise accountability, regulatory oversight, and structural risk allocation. Future frameworks will likely integrate regulatory compliance, enterprise risk internalization, insurance mechanism, and adaptive tort doctrines to address the distributed and adapted features of AI ecosystems. Contractual breaches by AI agents. Contract formation and AI. Current law requires parties with legal capacity. AI cannot contract independently, so responsibility falls on principals. Performance breach. If an AI fails to meet contractual obligations, developer liability may arise from poor programming or unreasonable autonomy. Owner liability may arise from misuse or poor instructions. The authorizing party bears liability if the contract allows AI autonomy. Risk allocation clauses. Parties can predefine responsibilities via indemnity, limitation of liability, or warranty clauses, classifying liability before harm occurs. Fraud committed by AI agents. As AI lacks subjective intent, however, algorithmic deception can be treated as equivalent to intent if the system is designed to misrepresent and the deployer benefits. Liability may extend to programmers, deploying firms, or principals who authorize deceptive behavior. Consumer protection. Statutory provisions often impose liability regardless of intent, ensuring businesses deploying misleading AI systems are accountable. Policy considerations. Innovation versus accountability. Strict liability can deter innovation, while lax liabilities increases social harm. Proportional balance is key. Clarity and predictability. Clear rules reduce litigation uncertainty and enhance market confidence. Global harmonization. Divergent models, EU, US, UK, Nigeria, risk fragmentation. International guidance like OECD, AI principles can provide alignment. Conclusions and recommendation. Autonomous AI challenges traditional legal categories of agency, intent, and liability. To ensure victims can obtain redress while fostering innovation, a multi-layered framework is recommended. Attribution to principles. Treat AI actions as attributable to authorized principles where foreseeable. Strict liability for high-risk systems. Apply no-fault liability for autonomous systems with severe potential harm. Mandatory insurance and compensation mechanisms. Guarantee victim compensation. Regulatory standards and compliance. Link liability defenses to adherence to risk management and oversight regulations. Contractual risk allocation. Allow parties to predefine AI risk in agreements. These combined mechanisms create a fair, predictable, and innovation-friendly liability regime for autonomous AI. Structured summary of AI, agentic AI liability frameworks. The complexity of AI liability arises from overlapping and legal doctrines, such as agency, negligence, product liability, enterprise risk, strict liability, insurance mechanisms, and regulatory governance. These doctrines are best understood as interacting layers within a responsibilities architecture rather than isolated rules. Core doctrinal liability models. Agency attribution. AI actions within delegated authority are attributed to human or corporate principles. This preserves continuity but raises questions about scope when AI evolves beyond programming. Negligence. Liability arises from inadequate testing, supervision, or monitoring by developers or deployers. Distributed causation in AI makes proof challenging. Vicarious liability. AI is analogized to an employee, enterprises bear responsibility for claims. This allocates risk efficiently but is imperfect due to AI's lack of legal personality. Enterprise risk theory. Corporation profiting from risk generating AI activities should internalize costs, promoting safety incentives but potentially affecting innovation. Product liability. Developers may be liable for defective design, insufficient testing, or inadequate warnings. AI's evolving nature complicates defect analysis, especially with post-deployment learning. Strict liability proposed for high-risk systems, attaching liability regardless of fault, simplifying compensation but requiring legislative support. Regulating non-compliance, breach of AI governance obligations like auditability, documentation, or risk assessment may support negligent claims, or presumption of causation. Together, these doctrines form a layered hybrid framework capable of addressing the distributed, adapting, and semi-autonomous characteristics of modern AI systems. Allocation of liability across the AI's ecosystem. AI systems operate within multi-actor ecosystems, and liability must reflect this complexity. Roles and exposure. Developers design and code AI systems, liable under product liability or negligence if defects, unsafe design, or insufficient testing foreseeably cause harm. Data providers may incur liability if biased or defective training data predictably leads to harm. Integrators customize systems for enterprise development, deployment, responsible for negligent configuration. Deployers control operational use, profit from AI, and make deployment decisions. Exposed under agency attribution, enterprise risk, contractual breach, and negligence doctrines. End users, limited liability unless misuse is intentional or reckless. Regulators, no civil liability but enforce administrative sanctions, fines, and compliance obligations. This structure reflects the reality that AI harm rarely stems from a single actor. Courts must assess proximate costs, foreseeability, and intervening acts, and shared responsibility. Liability by type of harm. Contractual breaches. AI contract bots are evaluated under agency and contract law. Principals remain bound if AI acts within delegated authority. Fraud and misrepresentation. AI lacks intent, but corporate recklessness or supervision failures can satisfy legal thresholds. Consumer protection statutes may impose liability without proof of intent. Market instability. Algorithmic trading disruptions are assessed via enterprise risk theory and regulatory oversight. Distributed causation complicates traditional fraud analysis. Antitrust collusion. Algorithm price convergent challenges agreement based framework. Cost may focus on foreseeability, and this is where I draw the curtain. Thank you.